When you hire a lawyer, you're counting on them to know the law, right? But what about the rules that they have to follow? Turns out there's this whole secret rule book, and guess what? It's all about protecting you. And if you know what's in that rule book, you've got a huge advantage. So today, we're going to pull back the curtain and break it all down step by step. We'll cover everything from how a lawyer could even get in touch with you all the way to their biggest duty, which might not be to you at all. All right, let's dive right in. First things first, how can a lawyer even get your business? You might think it's the Wild West, but it's really not. There are some super strict rules in place to stop them from being, predatory. And the rules draw a really bright line in the sand. I mean, sure, you'll see lawyer ads on TV or a billboard, that's totally fine. But what's not fine? Them calling you out of the blue or showing up at your door to get you to sign on. The whole point is to keep them from taking advantage of you when you're in a tough spot. And believe me, the rules get super specific. An ad can't promise you a win or create, these wild, unjustified expectations. If they mail you something, it's got to be stamped advertisement right on it. And get this, for injury cases, they have to wait a full 30 days before they can even mail you. It's all about giving you breathing room. Okay, so you found a lawyer and hired them. The second that happens, bam, a whole set of core duties just kicks in. And this is the absolute foundation of your entire relationship with them. It basically boils down to these three big pillars. First, competence. I mean, they've got to know what they're doing, right? Second, diligence. They have to actually work on your case and not just let it sit there. And maybe the most important one, communication. They have to keep you in the loop. Your lawyer gives advice, but you are the boss. The big decisions, like whether to accept a settlement or take a plea deal, that's always your call. Now, this is the one everybody knows or thinks they know, confidentiality. But its scope is way bigger than you probably think. It covers everything related to your case, and I mean everything. It doesn't matter where the info came from. It's not just what you tell your lawyer in a quiet room. It's a 24/7 shield protecting all your case-related information. So a lot of people get confidentiality mixed up with attorney-client privilege. They're actually not the same thing. Confidentiality is the big, broad, ethical rule. It applies everywhere, all the time. Privilege, on the other hand, is a much narrower evidence rule, and it only applies when you're in court. A good way to think about it is like this. Everything that's privileged is also confidential, but not everything that's confidential gets the special protection of privilege. So, does that mean this confidentiality thing is airtight, 100% unbreakable? Well, no. But the exceptions are few and far between, and they are really serious. A lawyer can and sometimes must break confidentiality to stop serious harm from happening in the future. We're talking about preventing a crime that's going to cause a huge financial loss, or to stop someone from getting seriously hurt or even killed. They can also reveal stuff to defend themselves if you, say, sue them for malpractice, or if a judge flat out orders them to. But as you can tell, these are super rare, high-stakes situations. Okay, let's switch gears and talk about the thing everyone wants to know about. The money. There's a whole section of the rulebook just for this, and it's all about making sure lawyers are fair and transparent with your cash. And rule number 1 is huge. A lawyer's fee has to be reasonable. They can't just pull a number out of thin air. And what's reasonable? Well, it's judged on stuff like how much time and effort they put in, how complicated your case was, and, what the going rate is for that kind of work in your area. You've definitely seen those no-win, no-fee commercials, right? That's what's called a contingent fee. It's super common in personal injury cases, but you're not allowed to use them in criminal defense or for most family law stuff, like getting a divorce. And why is that? Well, the system doesn't want lawyers to have a financial reason to, say, push you into a bad plea deal or rush a divorce just to get paid. So let's say you win a big settlement. How does the money actually get split up? It's pretty straightforward. First, all the case expenses, like filing fees or expert witness costs, get paid back right off the top. Then the lawyer takes their cut, that percentage you agreed on, from the rest. And as you can see, at the end of the day, you, the client, still get the biggest piece of the pie. But here's a question that keeps a lot of people up at night. What happens if you get that settlement money, but you and your lawyer don't see eye to eye on how much their fee should be? Don't worry, the rules have a very clear system for this. Any money that's not in dispute, so the part of the settlement that's definitely yours and the part of the fee you agree they've earned, that gets paid out right away.
But the chunk of money you're arguing over, that has to be put into a special, separate trust account and just sit there safely until you've sorted it all out. Your money is protected during the fight.
All right, now we're getting into one of the trickiest parts of legal ethics. It's called the duty of loyalty, and it's all about one simple idea: making sure your lawyer is 100% on your team with no competing interests. This quote from the rulebook really nails it. Basically, a lawyer can't represent you if there's a big risk that their work for you will be messed up by their responsibilities to someone else, another client, a former client, or even their own personal financial interests. Their loyalty has to be undivided. So, what does that actually look like in the real world? Well, a classic conflict is a lawyer trying to represent two people who are charged with the same crime. I mean, their interests are almost guaranteed to clash at some point, right? Another big no-no is a lawyer suing a former client on a case that's related to the work they did for them. That's banned to protect the first client's secrets.
And what about a lawyer wanting to go into business with you? The rules put up a ton of roadblocks. The deal has to be fair to you, everything has to be spelt out in writing, and this is the big one, they have to tell you in writing that you should go talk to a completely different, independent lawyer about the deal before you sign anything. It's a huge protection for you. Up to now, we've been talking all about the duties a lawyer owes to you, but they also answer to a higher power, so to speak. They have a massive duty to the court and to the entire justice system. It's called the duty of candor to the tribunal, which is a fancy way of saying they have to be honest with the court. A lawyer cannot lie to a judge, they can't knowingly use evidence they know is fake. And here's the kicker: sometimes this duty to be honest with the court is actually more important than their duty to keep your secrets. And this is where things can get really intense. Imagine a lawyer finds out their own client just lied under oath. They can't just ignore it. First, they have to try to convince the client to fix it, to tell the truth. If the client refuses, the lawyer usually has to try and get off the case. And if all else fails, they have an obligation to tell the judge what happened. Yeah, even if that means breaking confidentiality. The integrity of the justice system comes first. Period. So when you step back and look at this whole thing, you're left with a pretty big question, right? This entire complex web of rules is built to protect clients and to protect the courts. But does it all add up to a system that's more fair or just more complicated? That's the tightrope walk that every lawyer has to deal with every single day.